Yeah, I shouldn't be here. I should be here. So go ahead and give me a PR bond or something, Judge, if you don't mind, or something, because I shouldn't have to pay money to get out of jail. And whatever you want to do, you're the boss, but I'm asking for a PR bond. I'm going to court. I'm not taking no charges, no plea deals, no nothing. We're going to settle this. And this jailhouse, you got jailers letting trustees go out of here with not being searched or nothing. The FBI is going to be all in on this shit. I've been violated. My rights have been violated all kinds of ways, Judge. They didn't let me poop. They didn't let me sit on the toilet. They ain't didn't let me do nothing. They won't clean these cells. They won't do nothing. Yes, ma'am. Sorry, Judge.
Are you through?
Yes, sir.
Okay, Mr. Pruitt, you have the right to hire an attorney to represent you. You have the right to have the attorney with you while you're being questioned by peace officers or attorneys who represent the state. You have the right to remain silent. You are not required to make a statement, but any statement you make can be used in court against you, and you have the right to stop any interview or questioning at any time. Do you understand those rights?
Yes, sir. I'm not understand, but the thing is, I need to know whose jurisdiction I'm under. Because there has to, in order for me to be a crime, there has to be a victim. There's no victim statement. You can't have a victim statement with a witness statement. A witness statement goes with a victim statement. You can't have a witness statement without a victim statement. That's just against the law. You know that, Judge. That's a deprivation. Okay. Sorry.
You through, Mr. Pruitt?
I'm sorry, Judge. I'm tired. I've obeyed the law, Judge. I'm not a criminal.
Mr. Pruitt, let me explain one thing. To assault family violence charge, the state of Texas has the right to go forward with the prosecution without the witness's permission. That's the only law where that is available. So I just want you to know that. Now, okay. I'm going to ask you, okay, are you a citizen of the United States?
Yes, sir.
Are you currently on a bond for any other charges anywhere else?
No, sir.
You do not get a court-appointed attorney for a Class C misdemeanor. Like I said, this is a fine-only offense. Do you wish to make a plea before me today? Because it's a Class C misdemeanor, I can take a plea of guilty, not guilty, or no contest.
Not guilty. I will be my own lawyer, and I'll show y'all how the cases get beat.
Okay.
I'm good at being a lawyer. I done had 3 cases.
I am going to set you a bond of...
The courtroom session begins with the defendant asking the judge for a personal recognizance bond, while insisting that he should not have to pay money to secure his release. He repeatedly claims that his rights were violated and raises complaints about the jail conditions. The judge allows him to speak, but the defendant continues challenging the legal process and questioning the court's authority.
Against you to protect the victim of your crime?
No, my wife knows that I ain't no victim. My wife knows that she ain't no victim. She told Lieutenant Hellman told them to stand down and go home. They came back and rearrested me. They can't do that. Lieutenant Hellman told these officers to go home, and he said, if I have to come back out, I'm going to arrest you. And he came back and arrested me. You can't do that. The case is going to be thrown out, so I'm not worried about it. You can't do that. That's a violation of my civil rights. When your lieutenant told...
I understand. Okay. Your offense occurred in Precinct 3, so it's before Judge Elliser.
Yes, sir.
Do you have any other questions?
No, sir. Believe me, I would never hurt a woman in my life. I watched my mom get beat all her life. I would never hurt a woman. This is bull crap. Never.
Okay, post that bond and you can get out.
Yes, sir. God bless you, and I love you, bro.
Thank you.
All right, have a good day.
Hey, good afternoon. Let's go on the record. The court's going to call the matter of Antrilla 25 DR 30086. If I could please have entries of appearance.
Good afternoon, Your Honor. Matthew Beach, registration number 43116, appearing on behalf of petitioner who is seated next to me at council table today.
Good afternoon.
Good afternoon, Your Honor. Billy Skinner for Mr. Antrillo, 59058. Your Honor, if we may, could Mr. Antrillo be uncuffed so he can take notes during this?
So generally speaking, the court defers to the sheriff's deputies as to how they manage security in the courtroom. And so to the extent that the sheriff's deputy is comfortable with perhaps providing an extension or something along those lines, the court's fine with it, but otherwise they're responsible for security, so the court will defer to them.
Put an extra handcuff on there, so you should be able to.
For a sentencing and a punitive contempt matter, are the parties ready to proceed at this?
We are, Your Honor.
Yes, Your Honor.
Okay, so it's a little unusual as to how we're supposed to proceed with this, in part because the rules generally only require that the court provide Mr. Antrillo an opportunity to make a statement of mitigation if he wishes to do so. That said, the court generally feels that it's probably more appropriate to the extent that the attorneys also wish to make arguments or any other statements, both in support of the sanction to be entered and in support of mitigation. The court will entertain those as well. So Mr. Beach, as the kind of the process.
Things become more intense when the defendant argues that there cannot be a criminal case without a victim statement. The judge calmly explains that in an assault family violence case, the state can continue the prosecution even without the alleged victim's permission. Despite his objections, the defendant pleads not guilty and announces that he will represent himself.
Your Honor, as I stand before the court at what I hope will be the conclusion of this long and painful process, I would like to explain in my own words the impact these proceedings have had on my life. Making the decision to end my marriage was one of the hardest decisions I've ever made. After many years of enduring infidelity, financial control, coercive behavior, and emotional abuse, I finally found the courage to seek a divorce. Throughout our marriage, my husband controlled our finances, withheld money from me. If I refused, he would deliberately keep me. Oh, I'm sorry, I'm not going to say that. No one should have had to live that way. I devoted my life to raising our two children, largely without his support. I cared for our family while he pursued his own interests, and despite his considerable wealth, I often had to work multiple jobs simply to keep us going.
Good, just like him.
When I finally met with an attorney and began divorce proceedings, I believed my husband became aware of my plans because he had cameras in the home and closely monitored my conversations with family and friends. Before he
Okay, if that's true, it's creepy, but I have my doubts. I don't know.
could be served with divorce papers, he disappeared for approximately 2.5 weeks. I believe he used that time to move and conceal marital assets before the legal process could begin.
Probably.
When he was eventually served, he retaliated by filing allegations against... Oh, sorry, I think I got it wrong. Hold on.
I need to apologize, ma'am.
The process began to maintain the coverage. Everything what happened. Okay, maybe it is on this one. When he was eventually served, he retaliated by filing allegations against me that I maintained were completely untrue. As a result, I was ordered to leave my home and prohibited from returning. I complied fully with every order of this court despite the devastating consequences. For almost a year, I was unable to return to the home I had lived in for decades. Instead, I moved into my daughter's small apartment, sharing a limited space with several large dogs. I had almost none of my personal belongings, very little privacy, and no certainty about my future. My mental health deteriorated significantly.
The judge then sets a $500 bond and addresses whether a protective order may be necessary to protect the alleged victim. The defendant strongly denies that his wife was a victim and insists that the arrest violated his civil rights. He continues to argue that the case should be dismissed, while the judge keeps the discussion focused on the legal procedure and the conditions of his release.
The court would be willing to waive the waivable fees that would leave him a $73 mandatory balance. We never really got that far, so.
Okay. All right, I see there's a range on bench warrant. He'll owe 73.
Yes, that's correct.
What's the amount of the waivable?
He owes $2,045.80. Of that total, $73 is mandatory.
Okay.
And he's paid $125 so far.
Mr. Attorney General, what do you have to say?
Well, I guess I'm not entirely clear on the basis of the violation. I don't have, I'm not sure I've received documents regarding that. With respect to the underlying child support case, Mr. Lewis currently owes $21,415.70, and he has a current obligation of $66 a month. That's 66. And his last payment was in August of 2022. I also am not sure if Mr. Lewis has any representation in this matter or not.
No, I'll be representing myself.
Oh, okay.
Okay, so I'm sorry, I thought Mr. Gaddy was here on this. Sorry.
Two issues.
Okay.
The collections issue and then the probation violation.
Okay. So as to the collection issue, I can waive the waivable amounts. And Mr. Petherbridge, if you submit an order for that,
Will do, Your Honor.
Okay. And Mr. Lewis.
Can I speak now, Your Honor?
Yep, just a minute.
No problem.
Okay. Mr. Lewis, pursuant to Court Rule 6005, you have the right to the assistance of an attorney. So I can read you this section here if you're interested.
I've been representing myself since 2010, ma'am.
Okay, well, so then you've probably heard this a time or two, but we're supposed to read it to you every single time you come to court.
No problem.
Okay, so hold on just 1 second.
In another courtroom matter, a woman gives an emotional statement about the impact of her divorce proceedings. She describes years of alleged infidelity, financial control, coercive behavior, and emotional abuse, explaining that she struggled to support her children and eventually had to leave her home. Her statement paints a picture of a long and painful legal battle that had a major effect on her personal life.
To report to your probation officer monthly, as that they required, and that you failed to report on 1/26/23, and that you on 1/27/23 a call was placed to you and contact was made. You said you were going to turn yourself in on the warrant. The potential penalty in this case is up to 5 years and or $5,000. And I will read this verbatim. Advising the defendant of the charge, the maximum possible prison sentence for the offense, any mandatory minimum required by law, and the risk involving self-representation. In addition to that, I will offer you the opportunity to consult with a lawyer that you can retain of your choosing. Currently you're in custody, so I'd also appoint the public defender's office if you wanted assistance. That's my understanding that you are not interested.
No assistance needed, Your Honor.
Okay. This is your choice. All right, so how are we proceeding with the violation of probation?
Your Honor, I don't respect the reason I'm here today, but I will not disrespect your court because of others' egregious actions towards me. This is our first time meeting, and I plan on it being our last. Before Mr. Breckenbridge left, I would have liked to address the whole panel. So that I had just a few questions for him to set precedent so that everyone's stance could be evident and clear and no misinterpretations. But I see Mr. Breckenbridge tucked tail and ran.
Well, we're making a recording and he's still here. He just was out of the camera view.
Great. Mr. Breckenbridge, can you please state your full name and title for the record?
Mr. Lewis, this is not your hearing.
I can't address the panel?
There's no panel.
You have the probation officer, you have the court fines and fee officer, and you have the assistant general.
And everyone put their appearances on the record. So we're going to move it along.
No problem. I can get right to it. That is fine.
All right.
The law is my protection, and I shall find remedy in it. Before we begin this process, I would like to address the court. In addressing the court, I would like to fully read and completely express all information today without interruption.
The next case features another self-represented defendant who refuses to accept the court's explanation of the proceedings. He repeatedly tries to make broad legal arguments and insists that he should be allowed to present his information without interruption. The judge makes it clear that self-representation does not allow him to control the hearing and that he must follow the same procedural standards expected of an attorney.
So, as to the violation of probation, you can accept responsibility by pleading guilty to the violation or no contest. You can set this matter for a hearing in which we go forward, but this is not your hearing to run. Do you understand?
Yes, ma'am. I just wanted to address the court and put on record some very variable value information. And by
asking me questions is not putting information that you have on the record.
Yes, ma'am. I won't ask any more questions. Can I finish my statement? I have no more questions.
My question for you is, how are we proceeding with the hearing today? Are we proceeding with an acceptance, or are we proceeding that we need to set this matter for hearing?
Ma'am, this is not even a hearing that we should be having. If I could finish my statement, you could see that unless the AG has certain information, this is totally in violation, and I'm not able to express myself. Like I said, I have no more questions. I just would like to read the information I have, and then they can go which direction they want to after the information has been expressed, ma'am.
Okay, tell me if you feel like the petition for your violation of probation is wanton in some regard. Quickly, Mr. Taft Lewis.
I can finish. Thank you. I am the de jure. I am not an imbecile in law. I do not surrender my inalienable rights for any civil liberties. I am a five-fifths realized being and not a three-fifths Dred Scott compromised imbecile in law. I'm here today for the non-payment of what is commonly known as child support. For the record, there's no such thing as child support. The real reason I'm here today is because you're trying to enforce a contract /
For my question, we're going to adjourn this until you can get a hearing, and I'm going to appoint standby counsel of the public defender.
I don't want counsel, ma'am. I just want to finish.
I understand that. So what I want you to do, and you don't have to have Mr. Gaddy right next to you during your event, but your hearing for next week. But what I want you to do is talk to him about your available option, because what's very clear to me is that you're not listening to the questions that are being posed to the court. Right? I say, are we having a hearing, or are you accepting responsibility? I need an answer to that before we can go forward. You making a statement isn't evidence. That's not evidence, Mr. Lewis.
The judge eventually pauses the proceedings and explains that the defendant has the option of working with a public defender or standby counsel. Rather than treating him as a flight risk, the judge decides to release him on personal recognizance, but orders him to return for the scheduled hearing and report to probation. The ending shows the court attempting to balance the defendant's right to represent himself with the requirement that courtroom procedures be followed properly.
You don't get to just make statements. There's an order to things. So you can find that out for Mr. Gaddy. This case is adjourned until next week. We'll see you back on the 6th. Or exactly, Ms. Armstrong, does that give you enough time to do a writ, or do you need more time than that?
Judge, our office will request 2 weeks, just to ensure we have time.
We'll put it up 2 weeks.
Am I being remanded to jail, ma'am, or am I free to be released and come back in? Because I came in on my own accords, ma'am. I have no problem with coming back.
First, I'll put the recommendation from probation on the record.
Thank you.
The recommendation is for Mr. Lewis to serve 4 days in jail with 4 days credit, and to report to Agent Priest and report to probation on March 2nd in the office. Your Honor, I'd also like to make note that I have a note here that indicates. May we approach?
Yes. I'm sorry, ladies and gentlemen, for those of you, we need to have a private conversation because we have Mr. Attorney General is not here in person. We have to clear the courtroom. Okay, Mr. Taft Lewis, got additional information. You know, if you wanted to see me, there's a different way to do that. If you have a motion or part of that is by working with an attorney who knows how to navigate the procedures of the court. Again, your choice not to use an attorney. I still have the standby counsel for the public defender should you choose to avail yourself of their
hearing, because last week I could not speak also because he said it was your case and I would be able to have my turn to speak when I was in front of you. Now I'm in front of you and you're telling me this isn't the hearing also. So I didn't know how you guys were going to proceed. I just want to be heard on what information I have. Like I said before, I asked for this warrant so that I could get in front of you, so that I could.
Lewis, that's exactly what I'm saying, is that you had used the assistance of the public defender's office or your attorney who assisted you at the time of your case, you wouldn't have had to violate your probation to get in front of this court. I don't believe that you are a flight risk. I think you just made poor decisions. So I am going to release you, but you're to respond here in person, which is March 6th. At 1:30, and that is the date and time set for your hearing.
Yes, ma'am.
At that time, I would expect you to follow the proper procedure that any other criminal defense attorney would be held to the same standard. You still have the public defender at your disposal if you choose to consult with them.
No problem.
Would you also order him to report in person, probation officer?
You'll have to report to probation tomorrow, March 2nd?
Yes.
You'll report to probation on March 2nd to meet with your agent.
Which agent is that? Is that Agent Moses, Agent Miller, or Agent Priest?
Did you hear that, Mr. Lewis? The public defender is availing themselves to you.
I have no comment on that, but yes, I did hear him, ma'am.
I'm releasing you on PR.
Much appreciated, ma'am. I had 3 warrants, one from the court fees and fines. I had one from FOC and one from the violation of probation. Is that all warrants? I'll be released on PR?
Yes, and yes.
Much appreciated, ma'am. I will see you March 6th.